Welcome back, viewers. You're watching The Savera and I'm Vidhi Joshi. The K. Veeraswami versus Union of India case is a landmark judgment delivered by the Supreme Court of India on July 25, 1991, which addressed the critical issue of whether judges of the higher judiciary and Supreme Court can be prosecuted under the Prevention of Corruption Act 1947, and if so, under what conditions. This case set a significant precedent regarding the balance between judicial independence and accountability for criminal misconduct, particularly corruption. The ruling established procedural safeguards to protect judges from frivolous prosecutions while allowing for accountability, shaping how allegations against judges are handled in India. What is this case? The K. Veeraswamy case resolved around Kuppuswamy Naidu Veeraswamy, a former Chief Justice of the Madras High Court. In 1976, the Central Bureau of Investigation registered a first information report against him under Section 5, Subsection 2, read with Section 5, Subsection 1E of the Prevention of Corruption Act 1947, alleging that he possessed assets disproportionate to his known sources of income, amounting to around 6.41 lakh. The allegation surfaced just before his retirement in April 1976, after which he went on leave in March 1976. The CBI filed a charge sheet against him on December 15, 1977 before a special judge in Madras. Veeraswamy challenged the FIR in Madras High Court, seeking to quash the proceedings. He argued that the Prevention of Corruption Act did not apply to judges of superior courts because there was no single authority competent to grant sanction for their prosecution as required under Section 6 of the Act. He contended that the President who appoints judges acts on the advice of the Council of Ministers, and allowing the executive to sanction prosecution could undermine judicial independence. The Madras High Court, in a 2-1 decision in 1979, refused to quash the FIR, holding that no sanction was required since Veeraswamy had retired by the time the charge sheet was filed. The dissenting judge, however, quashed the proceedings, citing procedural lapses by the CBI. Veeraswamy appealed to the Supreme Court, raising significant constitutional questions about prosecuting judges. The Supreme Court, in a 3-2 majority decision, ruled that the judges of the High Court and Supreme Court are public servants under the Prevention of Corruption Act and can be prosecuted for corruption. However, to safeguard judicial independence, the court mandated that no criminal cases, including an FIR, could be registered against a sitting judge without prior consultation with the Chief Justice of India. If the allegations involve the CJI, consultation with other Supreme Court judges is required. The court also held that the President is the competent authority to grant sanction for prosecution, but this decision must align with the CJI's advice. Since Veeraswamy had retired, no sanction was needed in his case, and the appeal was dismissed. The case originated in 1976 when the CBI registered an FIR against Veeraswamy on February 24, 1976, followed by a charge sheet in 1977. The Madras High Court heard the case in 1979 and Supreme Court delivered its final judgment on July 25, 1991. The case spanned over a decade due to its complex constitutional implications and the need to balance judicial accountability with independence. According to the recent updates, in May 2025, the K. Veeraswamy case resurfaced in public discourse when Vice President Jagdeep Dhankar called for revisiting the 1991 judgment, describing it as a judicial legerdemain that created a scaffolding of impunity around the judiciary. The term scaffolding of impunity refers to the structures, systems, or mechanisms that enable powerful individuals or institutions to avoid accountability for their actions, particularly in cases of corruption or misconduct. Vice President Dhankar's remarks were made in the context of a recent controversy involving a Delhi High Court judge, Justice Jashwant Verma, linked to a cash on fire incident at his residence on March 17, 2025. Dhankar argued that the requirement to consult the CJI before registering an FIR shields judges from accountability and fosters corruption in the higher judiciary. He criticized the in-house inquiry mechanism developed by the Supreme Court, which involves a panel of judges verifying allegations against a judge, as unconstitutional and lacking transparency. On May 8, 2025, an in-house inquiry indicted Justice Verma and the report was forwarded to the President Draupadi Murmu and Prime Minister Narendra Modi. However, on May 21, 2025, the Supreme Court dismissed a petition seeking an FIR and criminal investigation against Justice Verma, who had been transferred to the Allahabad High Court, stating that the inquiry report had been acted upon. This decision reinforced the Veeraswami judgment's framework, emphasizing the CJI role in approving criminal proceedings against judges. Sanction for prosecution. The 1991 Veeraswami ruling came just 2 months after the impeachment motion against Justice V. Ramaswamy had been made. Justice Veeraswamy had retired by then and was not impacted by the ruling, but it is significant that the SC did thereafter allow the CBI to register a case against a sitting judge. However, this power has been used sparingly by the CJI. In 2019, for the first time, then CJI Ranjan Gogol gave permission to the CBI to register an FIR against Justice S.N. Shukla of the Allahabad High Court for alleged favours to a private medical college for MBBS admissions. Justice Gogol's predecessor, CJI Deepak Mishra, had recommended the impeachment of Justice Shukla, but the government did not act on it. That's all for now. Stay tuned to the Savera for more updates. Do like, comment and subscribe to the channel.